In this video, we are going to analyze the merger directive of the European Union through a case of the ECJ. In absence of any specific tax provisions, reorganizations in general may trigger taxation of capital gains. Domestic reorganizations or internal reorganizations are tax neutral. That means that taxation of the capital gain is deferred until a later disposal of the assets involved. Similar tax provisions for reorganization of companies of different member states are necessary for the completion of an internal market within the European Union. So we need the same tax regime for cross-border mergers than those that we have at domestic or internal level. In the case of the European Union, the directive in charge of regulating this kind of reorganization structure is Council Directive 2009-133. That in fact this one is a consolidated text of the previous one from the 90s that we have in this slide. The merger directive, the European merger directive, requires the companies involved in the operation covered to be qualified as a company from a member state. So the company, each company, has to take one of the legal forms listed in the annex to this directive. The company has to be resident within the European Union, and also the company has to be subject to one of the taxes listed in the annex. Once we know the kind of companies that are within the scope of this merger directive, it is required for the application of the tax regime included in this directive, it is required that a company from a member state, that we have said before, be involved in operation covered by Article 2 of this directive. The main operations covered by this directive are those two. Mergers, in which one or more companies transfer all or their assets and liabilities to another company, and in this case, the receiving company is the legal successor of the assets and liabilities. For example, in this example, we have A and B, and the A plus B results in a new company called C, and this one is the receiving company. But on the other hand, we have also operation that consists in divisions. In these cases, one company, C in our example, transfers all of its assets and liabilities, so actives and passives, to two or more new or existing company in exchange for shares representing the capital of the companies receiving the assets and liabilities. So in this case, C is split in two different companies, A and B, and C receives shares of those two new companies. Inside the directive, we can also find other kind of operation like transfer of assets or also exchange of shares. For check more or less how the ECJ is interpreting this merger directive, we can have a look to the case C1416 in the case Europark service. In this case, we have a request for a preliminary ruling. So as we all know, a preliminary ruling is a case in which a national court asks the ECJ for the interpretation of the primary law of the European Union. And in this particular case, the debate was centered into the interpretation of Article 49 of the Treaty on the Functioning of the European Union regarding the freedom of establishment. In this particular case, the requests have been made in proceeding between Europark, which has assumed the rights and obligation of the French company Carrefour. And from one part, we have Europark and Carrefour And on the other side, on the other part, we have the Minister for Finance and Public Accounts of France. So in this case, we have a merger between Europark and Carlsberg. Article 4.1 of Directive of Merger Directive provides that a merger, a kind of reorganization, shall not give rise to any taxation of capital gains calculated by reference to the difference between the market values of the assets in the moment of the reorganization and their value for tax purposes. So in the moment that we are having a merger, we cannot calculate the capital gains resulted by the difference between the market value in this moment and the previous value, the value that the company, the assets had in its account. By its part, Article 11 of the directive provides that a member state may refuse to apply the benefit contained in the merger directive if this reorganization, this operation has as its principal or unique objective tax evasion or tax avoidance. So the merger directive allows member states to establish in its domestic legislation the possibility of not apply this tax regime if we have no valid commercial reasons for the merger or in general the reorganization. Inside the French legislation, Article 211 provides that net capital gains and profits generated by or assets transferred from one company to another in the case of a merger shall not be subject to corporation tax. By its part, Article 210b provides that this special tax regime shall be granted where just if the operation is justified for commercial reasons or if the operation does not have as its principal objective tax evasion or tax avoidance. So inside the French legislation, this special tax regime provided by the merger directive only applies if inside the operation there is a commercial reason. Finally, Article 210c states that those provisions shall apply to transfer made to foreign legal persons by French legal persons only where those transfers were approved beforehand, so in advance, with accordance to the rules established in Article 210. So in the case of cross-border mergers or cross-border operation, French legislation established that before the permission of the application of this tax regime, the tax authorities have to check if they are complying with the reasons, commercial reasons, or not tax avoidance schemes. In our particular case, in November 2004, this Germany, Kernburg, Kernburg was dissolved without liquidation by its sole shareholder, Europac. So we have in this case a merger. The French company opted for the special regime for mergers in order not to apply the corporation tax for the capital gains arose. Consequently, this French company, did not declare the net capital gains and profits generated by the assets transferred from this one to Europac, which has his seat in Luxembourg. The French tax authority called into question the use of the special system for mergers on the following reasons. First, that the French company have not requested the ministerial approval provided for under the domestic legislation. And secondly, that this approval not requested for Kernburg will not in any case have been granted because the French tax authority understood that the operation was not justified by valid commercial reasons. So the main aim of the reorganization was tax avoidance or tax abuse. Finally, once these are the facts of the case, the ECJ decision was the following. In order for the taxpayer to know the extent of the rights and obligations that derives from the merger directive, a decision of the tax authority refusing, in this case the French tax authority, refusing that taxpayer a tax advantage under that directive must always be reasoned. So in the opinion of the ECJ, if one national authority, the French tax authority, refuse the application of the merger directive, it should be motivated or reasonable. As pointed out by the ECJ, this directive, the merger directive, lays down as a principle the deferral of taxation of the capital gains relating to the access transfer, in this case from one French company to one residence of Luxembourg. And this directive, as we have said before, allows the deferral in general, but just in one case not, when the operation has as the main objective tax evasion or tax avoidance. The French legislation that we are analyzing in this case refused in a general way to grant that referral unless the taxpayer first comply with the internal procedure established by the tax authority. So the court concludes, the ECJ concludes that member states may not have understand to a general presumption of tax evasion or tax avoidance, but it has to be studied in a case-by-case basis. As you know, if we follow the way of acting of the ECJ, the first thing that we have to check if we have a restriction in this case. As we have pointed out before, that legislation, the French legislation, treats cross-border mergers and national mergers differently. So this difference in treatment constitutes or creates an obstacle to the freedom of establishment. In general, we can say that we have a restriction of this fundamental freedom. Once we know that we have a restriction on this freedom, the following step is trying to identify if we can find a cause of justification for this restriction or this discrimination. According to the French government, the obstacle is justified by the overriding public interest reason linked to preventing tax evasion or tax avoidance, and also justified by the need of protecting the balanced allocation of the power to impose taxes between the member states. As the ECJ understood that the prevention of tax evasion or tax avoidance can be considered as a justification, then following and the last step is study if this justification is proportional or not. In the opinion of the ECJ, with regard to the overriding reason in the public interest in preventing tax avoidance or tax evasion, A tax legislation which introduces a general presumption of tax evasion or tax avoidance goes beyond what is necessary to achieve that objective. So in this case, the ECJ concludes that the French legislation went against the freedom of establishment according to the Treaty on the Functioning of the European Union. Thank you very much for your attention and see you in the next video.